Hello, welcome once again to Leto's Law. I'm Steve Leto. I apologize. I've got something. You can't catch it from me, most likely, but I'm coming down with, or I'm just getting over some kind of cold issue. You can probably hear it. I can hear it, but it's also causing me some discomfort in my chest. So I'm going to get winded, but I've got such a good story. I've got to do this. It can't wait. Daniel passed it along to me. And, I talk from time to time about the sovereign citizens, the people who claim that there's this secret set of rules. If you only understood it, you could step outside of the system and take advantage of your straw man, or go into court and unlock the secrets of the gold fringed flag, or drive without a driver's license, and so on. And a couple people who got wrapped up in this ran afoul of the law. And after being prosecuted in federal court and being convicted for what they had done, they appealed their convictions on the grounds that when they defended themselves, after asking to defend themselves, the court shouldn't have let them defend themselves because they were incompetent. So it's amusing on several levels, as these people often are. But the case I'm going to read to you about is the United States of America versus Heather Ann Tucci-Giraffe and Randall Keith Bean. I'm just going to refer to them as the defendants. It's too long otherwise. The case is out of the United States Court of Appeals for the Sixth Circuit, which is the circuit that Michigan is in. And it's case number 18-5752, which means that it all happened last year, I believe. And the appeals opinion was handed down September 24th, 2019. So this is brand new. This ink is still fresh. I apologize for the bad edits. There's going to be several because I'm having coughing fits, which just trust me on this one. Faced with financial challenges and rising unpaid bills, the individual has two legal options: shed the debt through the humbling act of filing for bankruptcy, or find a new source of assets. Randall Bean, with the other defendants' assistance, tried to find a new source of assets, an alleged trust fund of government money in his name. But the money was not his, and along the way, the two of them defrauded the United States of $31 million. At the resulting criminal trial, they each asked to represent themselves, a request the court honored. The trial did not end well for either of them, as the jury rejected their various fringe conspiracy theories. And on appeal, they now argue that the trial court should have forced them to accept counsel in view of their unusual beliefs. They're basically saying, look, we were making crazy arguments. We should have gotten attorneys. Because they knowingly and intelligently made this choice, and because self-lawyering does not require the individual to subscribe to conventional legal strategies or other orthodox behavior, we affirm the trial court's verdicts. So, backing up now, Randall Bean honorably worked for our country in the Air Force. At some point, he became convinced that the government was spying on the public, prompting his self-described quest into the world of conspiracy theories. His internet research led him to the straw man conspiracy theory. This is where the government creates for each new citizen a legal identification called a straw man that allows the Federal Reserve to hold in trust that citizen's inherent unlimited value. Proponents believe that by filing paperwork with the correct verbiage, they can tap into trust funds and use them as bottomless expense accounts. Timing is everything. This theory struck a chord with Bean at a vulnerable time when he owed more money than he could pay on his vehicle, several credit cards, and 4 personal loans. In his research, he came across the work of Heather Tucci-Giraffe, which did not help matters. She is a former lawyer who once worked as a prosecutor and a public defender. She ran a website, posted videos, and contributed to talk shows about the straw man conspiracy theory. She also produced several faux legal documents that purported to allow individuals to access their secret trust fund accounts. Seeing Tucci-Giraffe as a visionary who could make a difference, Bean reached out to her. She committed to help him dispose of his old energy and move forward and be creative in getting his financial house in order. Bean found an outlet for his creativity. While browsing Facebook, he came across a video posted by an anonymous user under the moniker of the Batman villain Harvey Dent. The video purported to teach viewers how to access their secret trust fund accounts, but in truth, it taught them how to commit wire fraud by exploiting a deficiency in the automated clearinghouse network that banks use to transfer funds online. Bean discussed the video with Tucci-Giraffe. She offered her own advice about how to perform the technique and directed him toward potentially helpful documents. On the evening of July 3rd, Bean gave the Harvey Dent idea a try. Logging onto his bank's website, he followed the video's instruction and entered the information it recommended, such as an account number, social security number, routing number, the Federal Reserve's numbers, and a variety of other things. And using these credentials, Bean made fraudulent payments in full on his personal loans, his credit card debt, and his car insurance. Bean then took to Facebook to spread the word that he had just paid off all his debts with his trust account. Easy as this was, Bean tried it again on July 5th. This time he bought certificates of deposit with Federal Reserve funds. With Tucci Giraffe providing moral support through video conferencing software, Bean bought CD after CD. He didn't stop until his computer's mouse ran out of battery charge. Then he went to bed. I guess that's the trouble with a wireless mouse when you're committing bank fraud. Bean awoke the next morning to find over $28 million worth of CDs in his bank account. Before long, he bumped that up to $31 million. And before long, he started cashing the CDs. With his debt cleared up and plenty of cash now in hand, he bought an $86,000 truck, as well as a $500,000 motorhome that had 2 bathrooms, marble floors, and a fireplace. By the way, these kind of facts are just thrown in for fun. These actually aren't crucial to the case. But when you buy a motorhome with a marble floor and a fireplace, you have too much money. Suspicious of his sudden fortune, one of Bean's banks froze his account. It also attempted to cancel the payments he made on his new truck and motorhome. Then Tucci Giraffe entered the picture. She advised Bean on how to protect his new assets by placing them in the name of a trust and prepared pseudo-legal documents on his behalf. Claiming to be his lawyer, she made phone calls to one of the banks and a dealership to persuade them that he rightfully owned the money he was spending. Her assurances worked, and the bank stopped canceling the payments. And that was just for a while. By then, as it happens, a federal investigation had begun. On July 11th, federal officers learned that Bean planned to drive off the dealership lot in his new motorhome with the fireplace. Officers rushed to the scene, arriving just as Bean started the engine. He refused to exit the vehicle, and agents had to remove him. One of the motorhome's other occupants provided officers with Tucci Giraffe's phone number and requested they contact her. Because, after all, she helped him out before, right? On the phone, Tucci Giraffe claimed that she was planning military operations. Officers arrested her in Washington, D.C., where she had gone after contacting the Secret Service to request a meeting with the president. And those facts are vital to the case because it shows you the mindset that's going on here. The defendants responded to their arrests with a flood of frivolous motions. They demanded hearings on their own identities, the identities of the arresting officers, and the identity of the presiding judge. They asserted that the United States courts cannot hold anyone except by their own consent, and that the United States is a bankrupt corporation. And the federal court opinion, as a joke, wrote that the United States, a tad more plausibly, is a bankrupt corporation, which is funny because obviously the national debt is, The defendants submitted hundreds of pages of pointless Uniform Commercial Code filings, allegedly related to something called the One People's Public Trust. They mailed the court an itemized bill seeking payment of over $46 quintillion. On and on it went. Concerned that such conduct might confuse a jury, the judge granted a motion in limine that barred the defendants from raising similar arguments at trial. Motion in limine is a hearing that's held before the trial starts, out of the presence of the jury, where they often ask the judge to make rulings on evidentiary issues or issues that arise in the trial of the case itself. And basically, the judge was asked to keep the defendants from raising these arguments, because these arguments have actually got nothing to do with the defense of whether they committed bank fraud. So the judge granted the motion. The defendants asked to represent themselves. And here's the interesting part. They asked to represent themselves. Remember that the woman was an attorney at one point in her life. The judge held a hearing for each of them, complete with the standard issue inquiries and cautions about self-representation. He said, if you guys do this, you understand there's ramifications. And he walked them through the whole procedure. The defendants provided some unusual answers, but after an extended colloquy, the judge concluded that they had knowingly and intelligently waived their right to counsel. He granted their requests. As a safeguard, he also granted a request to appoint standby counsel who can help the defendant during the trial and who can take over if the judge ends the defendant's self-representation. So they even had standby counsel. The defendants did defend themselves as best they could. They cross-examined the government witnesses, they introduced evidence, they testified on their own behalf, and they used their closing statements to justify their worldview. But their best was not good enough. The jury convicted Bean of bank and wire fraud, and both defendants of conspiracy to commit money laundering. The court sentenced Bean to 155 months and ordered him to pay over $500,000 in restitution. The court sentenced Tucci Giraffe to 57 months. Now, after that went down, of course, now they file an appeal. And they don't appeal on the legal merits. And that would appear to mean that they've admitted that they had no argument to take this money. The straw man stuff is nonsense. Now they're just saying, hey, look, we were acting so weird and crazy, we should have gotten attorneys over our own objections. On appeal, they argued the trial judge should have saved them from themselves. The right to counsel, the Sixth Amendment, has paternalistic and libertarian components to it. On one side, all defendants have the right to counsel, along with the right to have the government appoint counsel. The defendant cannot afford it, and so on and so forth. On the other side, all defendants, whether lawyers or not, have a right to represent themselves, what amounts to the right to reject counsel and to confront the government alone. So that's a pretty well-known thing. But the court actually spends 5 or 6 more pages explaining all this, just in case we're not getting it straight. The first question it answers whether the defendants properly surrendered their right to counsel. Did they do it knowingly and intelligently? It says, we have oscillated on the appropriate standard of review, at times giving the issue a fresh look, at times reviewing for plain error, and at times omitting any discussion. But nothing turns on this distinction here. When these defendants asked to represent themselves, they received all the vetting the law requires. He gave them the hearing, he asked them about it, he warned them about it, and they said they wanted to proceed. So they proceeded. The defendants nevertheless protest the knowledge and free will requirements of their waivers by pointing to portions of their hearing in which they gave odd answers to straightforward questions. When asked to be sworn in at the hearing, they both initially replied by saying, I am source of all that is. Tucci Giraffe flagged some instances in which she quibbled over meaningless turns of phrase, the difference between the true and the truthful, and the difference between pro se and pro per, which is funny because I've had discussions with people in comments under my videos where I'm talking about this, and I actually had one of these people say, Steve, you don't even know the difference between pro per and pro se. Yeah, so when you're trying to split hairs that don't exist, you're wasting your time. Throughout these verbal quibbles, they listened carefully to the judge's questions and they gave lucid answers. None of these answers suggested that they misunderstood the questions or had cold feet about representing themselves. So, like I said, they go on and on about this, and they claim that they were incompetent to defend themselves, they didn't know what they were doing, and they never should have been allowed to represent themselves. Which, of course, if you think about this, how ironic is it that somebody who says the government has no authority, the courts have no authority, none of this is real, I'm not the straw man, I'm not the all caps defendant, but I think the court should have forced me to have an attorney to represent me. It's absurd. Meanwhile, the Tucci Giraffe, who's the former lawyer, separately contests the 2-level enhancement she received for using her special skill as a lawyer to significantly facilitate the commission or concealment of a criminal offense. And basically what happened there is the courts, in sentencing her, enhanced her sentence and said because she was an attorney and she used the skills of an attorney to further a crime, they're allowed to do this and say because you used those skills to further the crime, we're going to actually enhance your sentence. And she says that she shouldn't have been held to that standard because she never actually set foot in a courtroom and represented this guy. But the courts point out, but she did, in fact, call at least one person and maybe 2 people over the phone and say, hey, look, I'm this guy's attorney. You better, and she inserted herself into this as an attorney. So the court said that's going to stand. So here's the story. I'll summarize it for you in case you didn't catch it or my various edits for my coughing confused you, and I apologize. How do I catch a cold when it's still summertime outside? Well, I guess it's not, right? Summer ended a couple days ago. First cold of the fall. United States of America versus Heather Antucci Giraffe and Randall Keith Bean, where sovereign citizens got arrested for their sovereign activities, went into court where they do not concede that anything is real and nothing exists, when convicted, say that the court should have ignored their nonsense and forced them to use court-appointed attorneys. It's what happens when this thing comes full circle. There you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.